Hi, I'm Michael Cossetto, a partner in Buddy Perry's corporate and commercial team. I'll be presenting today's presentation, Your Product Liability Responsibilities, What You Need to Know. Thank you for tuning in to this second and final presentation in our two-part mini-series on consumer law. My colleague Jason Sprague gave a presentation last week about misleading and deceptive conduct. I would like to begin by acknowledging and paying my respects to the Gadigal people of the Eora Nation, the traditional custodians on the land on which we are broadcasting from today. I would like to pay my respects to their elders, past, present and emerging, and acknowledge all Aboriginal and Torres Strait Islanders joining us today, also paying my respects to your elders, past, present and emerging. Even though I've been helping clients with consumer law issues for more than 25 years, when preparing for this presentation, it reminded me how much law there is about product liability and how complicated it can be. So it's going to be impossible to cram all you need to know into an hour session. So today's presentation will only be a high-level overview of the product liability laws set out in the Australian consumer law. So the areas that I'm going to focus on, firstly, I'll talk about the product liability regime in Australia, just giving you a sense of how broad the topic actually is. I'll then look at specific actions that relate to product liability under the Australian consumer law. I'll then look at the burden of proof, who has that burden of proof when trying to establish a claim. We'll look at some defences against a possible claim for product liability. We'll look at some of the time limitations and finally look at some of the remedies. We'll hopefully have some time at the end of the presentation for questions. So at any time while I'm presenting, if you do have a question, you can write it into the chat feature on the control panel and submit it. And then I'll try and answer them at the end of today's session. So let's get stuck into it. So first, product liability claims. They arise in a wide variety of circumstances, but broadly, I think there's two types of buckets. The first bucket, I think, would be product liability claims relating to unsafe products. That's where a product causes an illness, an injury or death to a person. But there's also another broader area of product liability claims, which I just call faulty product claims. That's where really a consumer is just trying to seek a refund or a replacement for a defective product. And yes, you know, there is some overlap because a faulty product can cause an injury or death. But liability for an unsafe product can also arise when there is no defect. A good example of that would be for example, button batteries or coin batteries. They aren't necessarily defective, but they can pose a safety risk if swallowed. It is important for our economy and people's well-being in general that products that we buy, use and consume are safe. The ACCC estimates that the annual cost of injury and death for unsafe consumer products is more than $5 billion. With around 780 deaths and 52,000 injuries a year. And this is why product liability remains a high priority for the ACCC. Australia's product liability laws are a combination of common law and legislation. A person who has been injured or has suffered some kind of loss or damage caused by a product can bring a claim for one or more of the following bases. They can bring a claim at common law they can bring a claim at common law for negligence. And negligence is a fault-based claim. They can bring a claim for breach of contract, or they can bring a claim under a variety of different statutes and legislation. But for today, I'm going to be talking about breaches of the Australian consumer law. And typically, when a product liability claim is made, it will involve multiple causes of action variously based on negligence, breach of contract, and contravention of the ACL. So it's not just one or the other. It often is a combination of all those things when a product liability claim exists. In broad terms, there are 3 federal regulatory authorities in Australia that oversee areas relevant to product liability issues affecting consumers. There are plenty of regulatory authorities at the state and territory level, but just for today's purposes, I'm just going to talk about the 3 federal regulatory authorities, just to give you a sense of the regime. Firstly, and probably perhaps most importantly, is the Australian Competition and Consumer Commission. The ACCC has a number of important investigative and enforcement powers. It's got the power to institute proceedings where there's been a supplier defective product, and it can seek remedies relating to consumer guarantees. And it can do this either in its own right or on behalf of any person who has suffered or is likely to suffer loss as a result of contraventions of the Australian consumer law. The ACCC is also responsible for setting mandatory safety standards, for overseeing product recalls, for mandatory reporting of deaths and injuries, and just other regulatory functions. The TGA, or Therapeutic Goods Administration, is Australia's regulatory agency for therapeutic goods, including medicines and medical devices. So the TGA regulates therapeutic products through pre-market assessment, post-market monitoring and enforcement standards. It licenses Australian manufacturers to manufacture therapeutic goods and medical devices, and it verifies and oversees manufacturers' compliance with those same standards for the sale of products that are manufactured overseas in Australia. The Australian Securities and Investments Commission oversees corporations and financial markets. And in particular, it regulates the provision of consumer credit, financial products and financial services. Now, today's presentation, I'm really just going to focus on product liability for non-financial consumer products. So when I'm talking about the regulators and the government, I'm probably usually going to be talking about the ACCC. Yes, there are products that the TGA will be involved in, those that have a therapeutic purpose, the therapeutic goods, medicines, medical devices, but I'm mainly going to be talking about products that fall within the regulation of the ACCC. Who is responsible for a product liability will depend on the particular cause of action and the particular facts. When it comes to a claim for negligence, it's well accepted that the manufacturer of a product owes a duty of care to the buyer of that product to safeguard them against the foreseeable risks of injury. But there's also others in the supply chain, like distributors, suppliers, and retailers, who have a duty not to supply defective products and a duty to pass on any warnings about particular products. Those distributors and suppliers are not expected to test products for safety, but they do have a duty to guard consumers from any dangers that are known to it or that it has reasonable grounds to expect. Also, if a party in a supply chain adds or modifies a product, including packaging and labelling, then that party will owe a duty to the buyer and user in respect of those changes, just as if they were the manufacturer. So for negligence, there are claims against the manufacturer, as well as possible claims against others in the supply chain. When it comes to a claim for a breach of a contract, it's the terms of the particular contract which will determine who is responsible for any defect in the product supplied and what remedies are available. Because we have a rule governing contracts, which is called privity of contract, contractual remedies are only available to parties to the contract. So in practice, this means a consumer will only have a product liability claim based on a breach of contract against the person that they bought the product from, not usually against the manufacturer. That being said, a supply chain is held together by a series of contracts, so it is possible to have a series of claims which might run down the supply chain, eventually reaching the manufacturer. But that can get too hard and complicated. And so for this reason, the importance of contract as a cause of action, or breach of contract as a cause of action in product liability claims, has reduced quite a lot in recent times, as people tend to rely on either a claim in negligence or under the Australian consumer law for a remedy. The Australian consumer law includes a range of consumer protection provisions that impose obligations in all parts of the consumer product supply chain, including manufacturers, suppliers, importers, all those parties along that supply chain, including retailers. Privity of contract is no barrier to relief. For the purposes of today, I'm going to focus on some particular actions that are available under Part 3 of the Australian Consumer Law. Under Part 3.1, an action can be taken against a person who makes false and misleading representations, which usually would arise in advertising or in respect of information that is provided with the product. Under Part 3.2, a consumer can bring a claim against a supplier or a manufacturer for breach of the consumer guarantees, which include guarantees that the products will be of acceptable quality and will be fit for purpose. Parts 3.3 and 3.4 of the Australian Consumer Law set out various product safety provisions which deal with mandatory safety standards and information standards for products. It sets out provisions about product bans, product safety reporting requirements, and product recalls. Part 3.5 of the Australian Consumer Law sets out a strict liability regime for the manufacturer of products which have a safety defect. Now, these provisions are broadly based on the Council of the European Union's Product Liability Directive, and it basically says, or the effect of the provisions is basically that a person who suffers some kind of loss because products have a safety defect can recover damages from the manufacturer of those products without necessarily having to prove any fault on the part of the manufacturer. It's just simply other products deemed to be unsafe. If yes, then the manufacturer will be liable. As I mentioned earlier, I will be focusing just on the Australian Consumer Law causes of action, not on negligence or breach of contract. So let's now dip in a little bit more detail on some of those causes of action that are set out in Part 3 of the Australian Consumer Law. Part 3.1 sets out some provisions which prohibit the making of false and misleading representations. Section 29 of the Australian Consumer Law sets out an exhaustive list of specific types of false and misleading representations. Those that are relevant to product liability include a prohibition on making a false and misleading representation about standard, quality, grade, composition, the style or model or the history of a product. Also, a representation about the performance characteristics or the uses or the benefits of use of products, and also representations about warranties and guarantees that might exist in respect of the products. A cause of action under Section 29 typically arises when false representations are made when advertising a product or in respect of information that might be provided with the product at the time of sale. For example, it could be information on packaging or labelling. It could be an insufficient safety warning notice or something of that nature. Most of you will know that when a party has a claim under Section 29 for false and misleading representations, then there will most likely also be a claim for the general prohibition against misleading and deceptive conduct and the Section 18 of the Australian Consumer Law. Those two causes of action, misleading and deceptive conduct and false and misleading representations, usually go hand in hand. And I think it would be fair to say that a claim for product liability today would almost always include a claim under Section 18 and Section 29. Part 3.2 of the Australian Consumer Law sets out a number of consumer guarantees which are relevant to product liability claims. So those that are relevant to product liability claims include the guarantee that the product must be of acceptable quality, guarantee that the product must be fit for any purpose expressly disclosed to the supplier. Products supplied by description must fit that description. Products supplied by reference to a sample or demonstration model must correspond to that sample or demonstration model in terms of quality, the state of those products and the condition of those products. And products supplied must comply with any express warranty that has been given. An express warranty doesn't necessarily have to be something that is written. It could be a statement or a representation that has been made to induce someone to buy the products. Typically speaking, these arise, for example, when a statement is made about the quality or the condition or the performance of a product, about the availability of spare parts for a product, or just about the availability of the particular product in the future. So anything that someone might say when a consumer is buying the product could be considered possibly to be an express warranty. But the consumer guarantee that arises the most in product liability claims is the first one, and that's the guarantee that products will be of acceptable quality. So let's spend a moment to look a little bit closer at that particular consumer guarantee. A product will be of acceptable quality if it is fit for all the purposes for which the product of that kind are commonly supplied, if it's acceptable in appearance and finish, if it's free from defects, if it's safe, and if it's durable. When assessing whether or not a product is of acceptable quality, there's a number of factors that need to be taken into account. For example, the nature of the product. Is it something that is a product that is made, or the purpose of the product has a safety purpose, or is it just a toy or some other product that doesn't really relate to the safety of a person? The price of the product will be relevant. For example, you can buy an umbrella for $10, or you could buy an umbrella for $100. But in a storm, you would expect that the umbrella that you buy for $100 is going to last better in high winds or a storm than an umbrella that you buy for $10. Also, things like statements that might be made with the products on any packaging or labeling of the products, any representations that are made about the products by the supplier or the manufacturer of the product, or any other relevant circumstances. They're all things that might be taken into account in determining whether the product is of acceptable quality. It's also important to note that the time for determining whether or not products are of acceptable quality is when the products are supplied to the consumer, not when a claim is made. One reason why the consumer guarantees arise in product liability claims is because the consumer guarantees cannot be excluded by contract. A term of a contract which tries to exclude, restrict, or modify a consumer guarantee will be void. Another reason why they often arise in product liability claims is because liability cannot be limited except where the price of the goods is more than $40,000, although that threshold is about to increase from 1 July to $100,000. So you can see that that will include a lot of products that people regularly buy, or the products are supplied for a purpose other than personal, domestic, or household use. Moving on now to parts 3.3 and 3.4 of the Australian Consumer Law. These parts of the ACL allow the government to specify and publish mandatory safety standards or information standards for particular types of products. Now, mandatory safety standards are generally introduced for products when the government considers it's reasonably necessary to prevent or reduce the risk of injury to a person. For example, there are mandatory safety standards for products like aquatic toys, for baby walkers, for prams and strollers, for bean bags, for projectile toys, for quad bikes, bike helmets, sunglasses, button batteries, products which might pose a safety risk, like hot water bottles. Also, motor vehicles. Sorry, not motor vehicles, but the jacks. The jack when you're changing a tire. The jacks and the support stands for motor vehicles. They all have some mandatory safety standards because they're all considered to be products that have some kind of safety risk, and the government wants to make sure that those products or products of that nature that are supplied in Australia meet those mandatory standards. So if a product is subject to a mandatory standard, then it must meet the safety criteria set out in that standard before it can be sold in Australia. The standards can relate to a lot of different features of a product. For example, the composition of the product, the way it's manufactured, the design of the product, the way it's constructed, the finish of it, the packaging and the labeling. So it can be across all those areas that the standard can relate. In addition to mandatory safety standards, the ACCC can set out what are called mandatory information standards. And those standards are put in place to ensure that the consumers are provided with other important information about a product, which helps them make a purchasing decision. Information and standards do not necessarily relate to safety aspects for a product. For example, information standards, or a good example of an information standard would be the labelling on tobacco products. Also labelling for cosmetics, and care labelling for clothing and textiles. So, the government is of the view these aren't necessarily, or for example, the information standard for labelling for clothing or care labelling isn't about safety. It's more to make sure that people like me, when you're doing the washing, don't shrink your favourite jumpers or that kind of thing. So it's there to protect the consumer, not necessarily about safety. There's also a bunch of voluntary standards that are often put together by industry groups. The industry groups usually put these standards together as a proactive way of trying to deal with either a safety concern or just some concern about the performance or reliability of particular products or families of products. Now, voluntary standards are what I just mentioned. They are voluntary, they're not mandatory. So if you don't comply with a voluntary standard, you're not going to get in trouble, and it's not illegal, but it is illegal to supply products that don't comply with the mandatory safety standards. The government can also impose permanent or interim bans on consumer products where it considers it's reasonably foreseeable that those products may cause injury. An interim ban will last for 60 days, but may be extended for another 60 days. And if there is a product ban, then the sale, manufacture, the possession, or export of products that are subject to that ban is prohibited. Examples of some product bans include the use of DHP in children's plastic toys. So DHP is a particular chemical that's used in manufacturing particular types of plastics. So that's been banned. There's also mini jelly cups that contain konjac. Konjac is a food additive that comes from a particular plant, and when eaten, it doesn't really dissolve that easily, so there's considered to be a safety risk. Novelty cigarettes. I remember when I was a kid, you could go buy a pack of what was called fags, which were just a candy. They look like a cigarette, so you could go around pretending you're having a cigarette. Well, those types of products are now banned. Sky lanterns are banned, and there's a bunch of other products which have been banned. And to find out what products are banned, you can look up the bans on the ACCC website, and I think the productsafety.com.au website. So there's a whole heap of products that fall within those categories. Moving on now to product recalls, also in 3.3 and 3.4 of the Australian consumer laws, there's basically a stringent regime for the recall of products that either do not comply with the prescribed safety standard, or products that have been declared to be unsafe products or permanently banned, or products that will or may cause injury to people. Now, many suppliers will voluntarily initiate their own recalls after they become aware that one or more of their products present a safety risk. And the ACCC usually doesn't get involved in a voluntary product recall, except where that recall hasn't been properly notified, or the ACCC is not satisfied with the recall strategy adopted by the supplier or the manufacturer. That being said, in some cases, the ACCC will initiate a compulsory recall. But if a product is identified as being unsafe, the ACCC will usually contact the supplier, and then this causes the supplier to recall voluntarily. And the reason for that is because if the ACCC initiates a compulsory recall, it will direct the supplier about how that recall is to occur, and it will enforce compliance. Whereas if the recall is voluntary, then the ACCC doesn't necessarily get involved, or it doesn't get involved as much, and the supplier has more control. The issues that should be considered if you're deciding whether or not a recall action is necessary includes the magnitude of the potential harm involved, the probability of the harm occurring, the availability and effectiveness of alternative action that might be undertaken to mitigate the risk, the degree of knowledge that there is in the market about the potential harm. A supplier, obviously taking a recall action can be a significant step. It can be very expensive, but obviously the safety of consumers is paramount. So if you do need to do one, then I think as a matter of practice, it's usually good to get the ACCC involved. Now, approval is not necessarily required, so you don't need to get the ACCC's approval to do a voluntary recall, but you do need to notify the ACCC within 2 days of steps being taken or the recall action being taken. Some other things to bear in mind, in addition to notifying and cooperating with the ACCC, a supplier who initiates a recall or undertakes a recall is expected to notify a bunch of other people. Some of those people include all the participants in the supply chain, because the whole idea of a recall is to try and recall the product, including the product that hasn't yet been sold to consumers. So you want to notify people all along the supply chain about the product to be recalled. Also, there may be other regulators that might need to be notified, so it might not just be the ACCC you need to tell. For example, if the recall relates to a food product, then you would need to also notify the Food Standards Australia and New Zealand. If it relates to a motor vehicle, then there's another government department, I think it's the Department of Infrastructure, Regional Development or something. They keep changing their names. If it relates to a therapeutic good, then you need to notify the TGA. If it's for a veterinary product, then it's the Australian Pesticides and Veterinary Medicines Authority, and the list goes on, right? So there's a number of other regulators that you might need to notify. And if the recall relates to a product that has been supplied overseas, then the supplier needs to send a recall notification to any person outside of Australia to whom they have supplied the product. If you do need to undertake a recall, as I mentioned before, I think it's best to engage with the ACCC at the earliest opportunity. It's always good to discuss with the ACCC the recall strategy that you have, the communications plan that you have, and basically you engage with the ACCC to ensure that the regulator is happy with the proposed action. That way, the ACCC will just monitor the recall without necessarily getting too involved. It'll give the supplier or the person conducting the recall a bit more leeway in the way it's conducted. And that can be really important because, as I said before, taking the step to do a recall is a big thing, and it can affect the brand, can affect, and it's a very expensive exercise. So in summary, I think the product safety recall process involves, first of all, obviously stopping the supply of the product, informing relevant authorities of the problem and the steps that you're taking to recall the product, warning consumers about the hazards that the product presents, and also one thing that I didn't mention, which was that usually a recall will involve offering some kind of remedy in the form of, repair, replacement, or refund of the product. We're moving on now to Part 3.5 of the Australian Consumer Law. It sets out a number of specific actions that can be taken against a manufacturer of products for those products that the manufacturer has manufactured that have what is called a safety defect. Now, the action will give a person who's been injured or whose property has been damaged as a result of a product which has a safety defect, a right to compensation against the manufacturer without necessarily having to prove, or without having to prove negligence, breach of contract, or breach of statutory warranty. So it's just a strict liability provision in the Australian Consumer Law. Now, there is no limit on the amount that can be claimed. It can be whatever it will be, I guess, whatever the loss or damage that has been suffered. The actions under Part 3.5 lie against the manufacturer. So it's important to determine, well, who is the manufacturer of a product? And the definition of manufacturer is broad, and it includes a supplier who imports the products or a supplier who applies their own brand to a product. So this means that importers or parties who might parties who might buy a white label product and then brand it with their own brand, they need to ensure that appropriate levels, they need to ensure that they have appropriate levels of insurance in place, or product liability insurance, to cover potential claims for any product that have a safety defect. It's just an area that people need to be aware of when you're importing a product. Don't just think that you're not the manufacturer because someone else made it overseas. If you're importing it, then you will be deemed the manufacturer, and the buck under the Australian Consumer Law will stop with you. Oh, sorry. So what is a safety defect? A product has a safety defect if there is an absence of a level of safety that persons are generally entitled to expect, having regard to all the circumstances, including a prescribed list of things that the courts will generally take into account when determining whether there is a safety defect. So the courts will look at the manner or purposes for which the products are being marketed. They'll look at their packaging. You know, are there any warnings or instructions on the product? How the product's usually used? Has there been a shift in the community standards since the products were supplied? All those sorts of things will be taken into account when determining whether there is a safety defect. But basically, as I mentioned before, it's really just whether or not the product is considered to be safe in terms of what a person would generally expect for that type of product. The liability of a manufacturer under Part 3.5 can be significant. As I said before, the liability can be unlimited, or there is no limit of liability on what can be claimed under those provisions. But in addition to that, a manufacturer can be liable for not only the loss or damage that might be suffered by an injured individual, but also for the loss or damage that's suffered by a person other than the injured individual. For example, this would include claims by a spouse or a dependent of that person. It can also include a claim for loss or damage suffered by a person if other products are destroyed or damaged because of that unsafe product. They can be the products of the person who originally purchased the unsafe product, or they could be someone else's products. So it's not limited, it's to any particular products. And also, a manufacturer can be liable for loss or damage suffered by a person if the product with the safety defect causes some damage to land, buildings, or fixtures. So you can imagine, and I guess an example would be that if an electrical product caused a fire, then obviously, then the manufacturer could become liable for any damage caused as a result of that fire to any buildings or fixtures. So hopefully you can see that the liability of a manufacturer under this particular part can be quite significant. I would like to now just quickly touch on a fairly recent development in product liability law. I'll get it out in a sec. So in April 2017, the Consumer Affairs Australia-New Zealand organisation released its review of the Australian consumer law. The key recommendation of that review was the introduction of what is called a general safety provision. And this type of provision is recommended to rectify what Consumer Affairs ANZ saw as a deficiency in the current product safety regime that we have in Australia. As we've just seen, suppliers have existing obligations under the Australian consumer law regarding product safety, but a lot of those obligations are predominantly reactive. They only expose the supplier or the manufacturer to a consumer claim after injury or death has been caused. A general safety provision, on the other hand, would be a proactive provision that would impose a statutory obligation on suppliers not to supply unsafe products to consumers. The general safety provisions are already in effect in several overseas jurisdictions I've listed on the slide, including the UK, European Union, Canada, some countries in Asia, and also in South America. But what does it mean? Well, for manufacturers, it's probably going to mean that you will need to undertake additional product testing. You probably need to provide additional technical documentation for products that you supply, you're going to have enhanced labelling and instruction to make sure that people are aware of any safety issues concerning products. For suppliers and importers, it'll basically mean a need to disclose any safety risks that come with particular products. It'll mean keeping documentation on the origin of products, and also monitoring the market for any safety issues, not necessarily just in the domestic market, but also overseas. So you can see that with this extra general safety provision, it's likely to come with a bit of extra compliance cost. At this stage, the introduction of the general safety provision has been stalled because of COVID, but it's increasingly likely that we will have the general safety provision introduced in the near future. It certainly is on the ACCC's agenda. Let's now move on to burden of proof. But maybe just before that, let's do just a quick recap. So far, we've been talking about or focusing on the causes of action under the Australian Consumer Law in Part 3 of the Australian Consumer Law. We looked at possible causes of action for false and misleading representations under Part 3.1. We looked at consumer guarantees under Part 3.2. We then went on to mandatory safety standards and mandatory information standards, product bans and product recalls under Parts 3.3 and 3.4 of the Australian Consumer Law. And lastly, we looked at the strict liability for manufacturers for products with safety defects under Part 3.5 of the Australian Consumer Law. So if you do have a cause of action, then we need to consider, well, who has the burden of proof? The simple answer, I guess, is that the person making a claim has a burden of proof, and they need to prove all the essential elements of the claim. The standard of proof is the balance of probabilities, that is, that the claim is more probable or not, or that the event or the conduct that occurred was more probable than not. And in addition, a defendant to a claim also bears an onus of establishing any affirmative defence that they might have, and they also have to prove that on the balance of probabilities. As I mentioned, some provisions of the Australian Consumer Law are strict liability provisions, and that basically means that the person making the claim doesn't necessarily need to prove that there was any fault on the part of the defending party, but only that the product didn't comply with the particular thing. So, for example, in the case of a consumer guarantee, the claimant only needs to establish on the balance of probabilities that the products either were not fit for purpose or were not of acceptable quality. And, in the case of a defective products action, by that I mean an action against a manufacturer for a safety defect, the claimant only needs to prove that the product had the safety defect, that is, that it wasn't as safe as persons are generally entitled to expect. They don't necessarily have to show that the manufacturer has done anything wrong. It just is either is the product not compliant, and if so, then they've proved their position. Sorry. So generally speaking, the person making a product liability claim must establish that the loss or damage has been suffered, that the relevant conduct is either in the breach, the relevant conduct contravenes one of the provisions of the Australian Consumer Law, and that the loss or damage was caused by the manufacturer's or the supplier's conduct. There are a number of defences to product liability claims. I'm not necessarily going to talk about all the types of defences because it really depends on the cause of action that is taken. And we know that, as I mentioned before, with product liability claims, there's lots of different types of actions, and similarly, there are lots of different types of defences available. But I just want to talk about a couple of them that are available under the Australian Consumer Law. The first one relates to the consumer guarantee about acceptable quality. In section 54 of the Australian Consumer Law sets out some defences to that cause of action. For example, a claim for breach of the consumer guarantee or that products are not of acceptable quality doesn't apply where a consumer causes them to become of unacceptable quality or fails to take reasonable steps to prevent them from becoming of unacceptable quality. For example, the consumer doesn't maintain the product the way that it should be maintained. Also, it doesn't apply if the products are subject to abnormal use. It also doesn't apply if the reason why the product would not be of acceptable quality has been drawn to the attention of the consumer. A good example would be the sale of seconds or the sale of products which have little defects, or scratches or marks or those kinds of things. So yeah, you can't bring a claim for acceptable quality if you knew about that at the time you purchased the product. And also there is a defence if the consumer has examined the product before buying it, and that examination ought to have revealed that the products were not of acceptable quality. So if the consumer bought the product knowing that the product wasn't of acceptable quality, well then that's a defence to a claim. Similarly, with defences for under parts 3.5, that is the claim that a consumer has in respect of a safety defect of a product. So if you have a claim, then the manufacturer will have a defence if the product was defective only because the manufacturer complied with the mandatory safety standard. So obviously if they are required to comply with the standard and it turns out that the product is still unsafe, they should be held liable. Also in the case of contributory negligence, or maybe not contributory negligence, I think I've got that wrong on my slide. It should be the scientific or technical knowledge defence, and that is where the scientific or technical knowledge at the time of the products was such that it was unable to discover the defect. So sometimes with a product you don't really know it's unsafe until many years later, when there is scientific or technical knowledge about the product which shows that it's unsafe. So obviously a manufacturer has that defence if at the time that knowledge was not known. Also, a manufacturer has a defence if the defect did not exist when the product was supplied by the manufacturer, or there's also a defence in respect of components. So if there's a defect in a component, and the defect is only attributable to the design of the component, the label on the component or the instructions or warning given with that particular component, then it doesn't necessarily apply to the whole product. So the point, I guess, is that there are some defences. It can become complicated. As I mentioned before, there's lots of different causes of action, and likewise, there's lots of different types of defences. That really depends on the cause of action that is taken. Let's move on now to time limits. And again, with time limits on product liability claims, again, this is quite complicated. There's a myriad of different statutory provisions that apply. There's lots of different types of actions that can be taken. For example, under the Australian Consumer Law that we've just been talking about, we've seen that there's actions that can be taken under 3.1, 3.2, or all parts of parts of Chapter 3 of the Australian Consumer Law. And there are different time limits that apply depending on the type of claim. So For consumer guarantees, a claim that is brought against a manufacturer for breach of a consumer guarantee, there's a time limit of 3 years after the consumer becomes aware or ought to have become aware that the consumer guarantee hasn't been complied with. Now, if a supplier is bringing a claim against a manufacturer, because there's 2 ways that a claim can be brought under the consumer guarantee provisions. It could be initiated by the consumer directly against the manufacturer, or the consumer can go against the supplier and the supplier against the manufacturer. The time limits are a little bit different depending on which way it happens, but the 3 years applies to a claim directly against the manufacturer by a consumer. If there is a safety defect, so I'm talking about claims under Part 3.5, the action must be brought the earlier of 3 years after the consumer becomes aware or ought to become aware of the circumstances giving rise to that safety defect, and 10 years after the supply of the product. So there is a time limit of that, or that stop, a long stop of 10 years for claims under Part 3.5. For other claims under the Australian consumer law that involve personal injury, for example, a claim under Part 3.3 or Part 3.4, or a claim in respect of non-compliance with the guarantee. There's also, if it involves some kind of personal injury, then the time period is different. So the actions can be brought, I think this should be inserted the earlier of. I've noticed a mistake, it should read the later of. So it would be brought the later of 3 years after you become aware that death or injury was attributable to the contravention of the ACL, or 12 years following the act or omission that's alleged to have caused the death or injury. So again, the purpose of this slide is really just to show it is quite complex, and but I think the take-home message is you should be thinking 3 years, but also there is that long stop of either 10 or 12 depending on the circumstances. In terms of remedies, again, we're going to see that it is quite complicated, and it really depends on the type of action that is taken. But broadly speaking, the types of remedies that are available include monetary compensation, and that could be either pecuniary or non-pecuniary loss. The courts also have the ability to grant injunctions, to restrain breaches or attempted breaches. There's also provisions in the Australian consumer law, and in particular it's sections 237, 238, where the court has power to make any orders it thinks fit or appropriate against a person who's been involved in the contravention of consumer protection provisions. So that's quite broad. That can include, adverse publicity orders and a wide range of other types of action. Under the Australian consumer law, a person other than the injured party can claim compensation. I think I mentioned that when we were talking about Part 3.5. So another person or a person other than the injured party can bring a claim for compensation when they also suffer some kind of loss. And also it could be someone who's suffered loss in respect of their products or buildings and fixtures that have been damaged as a result of a product that has been the subject of a safety defect. But generally speaking, there's a wide variety of remedies, and it will really depend on the action taken and who actually brings that action, because under the Australian consumer law, there's a number of people who can bring action, including the ACCC. So sometimes the ACCC will initiate proceedings, and the types of remedies available include those pecuniary penalties for corporations, which can be up to the greater of 10 million or 3 times the value of the benefit received, and 10% of annual turnover. So quite a wide range of remedies that are available. Now we're almost there to the end. I just thought I would end by just quickly running through a couple of examples of action that has been taken by the ACCC. Most of you would have heard about the Cossetto airbag recall. Just to put this into perspective, it is the world's largest automotive recall. It affects more than 100 million vehicles. More than 3 million vehicles have been affected in Australia alone. To date, 99.9% of Cossetto airbags have been successfully recalled. So that, just to put that in the scale, that is a hell of a lot of airbags that needed to be recalled from 3 million motor vehicles in Australia alone. The cost of that and the coordination of that recall is difficult to comprehend. But as indicated on the slide, it is necessary because it's caused more than 350 serious injuries and 33 deaths globally. So certainly worthwhile doing. And then another example, I guess, is the decathlon, which is still on foot. The ACCC commenced proceedings against Decathlon in July 2020 for the sale of various sporting products, basketball rings and backboards and swimming pools that didn't comply with the consumer goods safety standards. Interestingly, Decathlon recalled 51 different products, including products that were the subject of the recall, the subject of the proceedings, and this case is ongoing. So, we need to watch this space. Just looking now to see if we have any questions. I know that we're almost at the end. Just checking to see if you have any questions, please send them in. Yeah, look, there is a question from someone just asking about something that I haven't really covered, which is the negligence and contracts. I did mention before that with contracts, that's probably not a cause of action that is commonly used, just because of the Australian consumer law, where a consumer can bring a claim directly against a manufacturer. But look, it does happen. As I mentioned, with product liability claims, it's really just a combination of all three. Negligence claims coupled with breach of contract and breach of various provisions of the Australian consumer law, almost always including misleading and deceptive conduct and false and misleading representations. But the main thing, so I think the main takeaway from this is that it is a complicated regime. And if you are selling products in Australia, or you are an importer or a manufacturer of product, then you really need to ensure that your products meet safety standards and are manufactured to a standard that is acceptable by our community, and that to protect yourself, you should be taking out, make sure you have appropriate product liability insurance. But that looks like it brings me to the end of today's session. We are running out of time, so thank you for joining me. I hope that you got something out of today's session, and we'll hopefully see you again soon. Thank you.